So hello again. Um, this is Rob Folland again, and want to welcome everyone to the TMA Florida's first listen and learn of our series. We're planning on putting these on, hopefully every other month or so. As I said, this is the first one that we're doing. With me today are Matt Hale and Amy Mayer, excuse me, and I'll let them introduce themselves momentarily, but I want to let you know that we're here to talk today about how to survive Subchapter 5 of Chapter 11 of the Bankruptcy Code, particularly as a secured lender, but we're going to get into some basic concepts with respect to Subchapter 5 as well. So briefly, by way of background, again, I'm Rob Folland. I'm with Barnes and Thornburg. We're an AmLaw 100 law firm with 23 offices around the United States. I'm primarily with the Palm Beach Gardens office, but I live in Naples, Florida, love it down there and the like. End up traveling a lot around Florida to work on things. I focus my practice primarily on bankruptcy, receiverships, fraud investigations, and complex commercial litigation. And then turn it over to you, Amy, for your introduction.
Thanks very much, Rob. Good afternoon. My name is Amy Denton Meyer. I'm a shareholder at Stichter, Rydell, Blaine, and Postler in Tampa. For the past 20 years, I've done predominantly debtor side Chapter 11 work. I also serve as a Subchapter 5 trustee in cases filed in the Tampa and Fort Myers divisions of the bankruptcy court. I've been appointed in somewhere around 80 cases to date since SBRA became effective in early 2020. Now I'll turn it over to my partner, Matt Hale.
Hi, my name is Matt Hale. I'm also a shareholder at Stichter Rydell here in Tampa, and I represent businesses and individuals in Chapter 11 cases, other insolvency proceedings, represent creditors in all kinds of bankruptcy cases and litigation, and also fiduciaries in distress situations like ABC assignment for the benefit of creditors cases. So with that, I think I'll kick it off here, see if I can control the slides. So we're here to talk about Subchapter 5 from a secured lender perspective. So first wanted to talk for a second about what is Subchapter 5. And it's a subsection of Chapter 11 of the Bankruptcy Code, basically a specific type of Chapter 11 bankruptcy case. It was implemented in 2019 with the Small Business Reorganization Act. The stated purpose of Subchapter 5 was to streamline the process for small businesses and enhance access to Chapter 11 for those small businesses. So some of you may have been involved in traditional Chapter 11 cases for small businesses as lenders, and for those small businesses in a traditional Chapter 11. I think typically what you would see is either a sale process if the company owned any significant assets, or you could see a 5-year standalone repayment plan proposed and confirmed. But the debtor would have a number of hurdles to overcome to get the confirmation. One of those would be what's called the absolute priority rule, which generally would inhibit equity from retaining ownership in the business unless they satisfied certain requirements, which I think Rob will talk about a little bit more later. So these hurdles, I always felt as a Chapter 11 debtor lawyer, I could overcome them, but it just created a lot of litigation and increased the expense for these cases. As a secured lender, you also might have had to deal with a creditors committee. I remember seeing creditors committees appointed in small business cases, and one, they love to go after secured lenders when they can, and two, the cost of a creditors committee in a small business case can really just tank a case with another set of lawyers. So in Subchapter 5, I think that the small business case process is more streamlined. Some of these hurdles have been removed. There's no creditors committee. Instead, you have a Subchapter 5 trustee like Amy who takes an oversight role, similar in some aspects to what a committee might serve. And generally, there's just an easier path to confirmation for these debtors. There's just less to litigate about, and I think mainly the lack of the absolute priority rule, and the requirement that you have to have at least one creditor class that's impaired, except the plan. That's not required for a Subchapter 5 case. Those two, I think, removal of those two requirements really streamline the process. And so I'm going to talk about eligibility, and that's which types of debtors are eligible for Subchapter 5. I wanted to make one more point before I turn to that. So this is geared towards secured lenders, and for Subchapter 5, really the treatment provisions for secured lenders didn't really change at all. Debtor still has to pay a secured lender the value of its collateral over time with the till rate of interest. And the till rate ain't what it used to be for debtors. It's a lot higher these days. And so I have talked to some secured lenders who lament Subchapter 5, but I think I guess one perspective is that the treatment really is the same, and I think it helps debtors really wipe out unsecured debt and address ballooning unsecured debt and spend less money getting the confirmation.
Hey, Matt, you mentioned till interest rate. Can you just briefly explain what that is and how you determine interest rate in bankruptcy?
Sure. Yeah. So the interest rate, the till rate of interest is generally prime plus 1 to 3. There's different cases that 1 to 3%. Different cases might expand on that differently, but generally I think that's the accepted standard. And so prime I think is at 8.5% now. So if you have to pay the secured lender the value of the collateral over time with that interest rate, that's what the baseline treatment is for secured lenders, and that hasn't changed with Subchapter 5. Thank you, Rob. So eligibility, there's a number of different kind of guidelines that guideposts Congress implemented. So you get these benefits, but there's also limited access to Subchapter 5. And if you're a secured lender and you decide you don't want your debtor to be in Subchapter 5 or want to exert some leverage on the case, eligibility would be a good place to start. Currently, the debt limit is $7.5 million. So a debtor with more than $7.5 million in debt would not be eligible for Subchapter 5. And that applies to liquidated and non-contingent debt, which I'll talk about those nuances in a second. And so at this point, unless Congress acts, that limit will go down to about $3 million next year, next June. I know there's some movement in Washington to keep the debt limit at 7.5 million, possibly raise it to 10 million, but I don't think there's anything has been too far advanced at this point. Second, the debtor must be engaged in commercial or business activities. Can't be a publicly traded company that is a reporting company, or a single asset real estate debtor. And a lot of these eligibility issues, and I'll talk about all these in turn, but a lot of these eligibility issues are pretty fact intensive, and they need to be raised early in the case. Go to the next slide. All right, so the first requirement is the debtor engaged in commercial or business activities. I think at the beginning when Subchapter 5 rolled out, there was a little more litigation about this issue as the courts were maybe a little more uncertain. I think the law's begun to settle a little bit, and I think the provision is interpreted pretty broadly. The first case listed here, this vertical mat construction case, is a case I filed and argued the briefing on this issue with Judge Vaughn in Orlando. It was essentially a liquidating bankruptcy case. The company was a subcontractor, had been hit with hundreds of construction defect claims, lost its insurance, couldn't get new insurance. And the question before the court was really whether a liquidating company could qualify as being engaged in commercial or business activities. And the court decided that having bank accounts, collecting accounts receivable, actively trying to liquidate your assets met this standard. So I think my view is that for a business, this standard is usually going to be pretty easily met. I think where you might see more litigation on this issue is with individuals. Individuals can also file Subchapter 5 cases. That's what this Henry Thurman case looked at. An individual just had basically an inactive company on, with the Secretary of State, and tried to argue that was sufficient, but the court didn't buy that. So this again is a pretty fact-intensive issue, but it's interpreted fairly broadly at this point, I think. Next slide. I think I skipped one here. So publicly traded companies, reporting publicly traded companies don't qualify. And I emphasize reporting because I had a case where we represented some equity holders in a pink sheet penny stock company that was listed on some exchange, and they didn't file reports with the SEC. So they did still qualify based on the text of the statute for Subchapter 5. So a reporting public company does not qualify for Subchapter 5, and also an affiliate of a reporting public company does not qualify. And I'll get into what an affiliate is here next. So the affiliate definition is it's on the slide here. Generally speaking, it's a parent or a subsidiary of a debtor. There's a 20% ownership threshold. Some type of management companies might apply if they run the operations of the debtor. And next, the reason affiliate is important is if you have a couple of different debtors that all file and they're all affiliates, to determine whether the filing satisfies that $7.5 million threshold, you would aggregate all the affiliate companies to determine whether they're eligible for Subchapter 5. And looking at that $7.5 million number, the only debts counted are liquidated and non-contingent debts. So non-contingent debts are debts where all events necessary to give rise to liability have taken place before the bankruptcy filing. Example of, I think, a non-contingent or an example of a contingent debt might be a conditional guarantee where it's dependent on default by the primary obligor before a guarantor is liable. I don't think you see those very much these days. And then liquidated is the second requirement. That needs to be liquidated, and that is satisfied where the amount of the debt is determinable by some fixed certain process. So like a loan balance could change if you're trying to enforce just a typical secured loan, but you can figure out the balance by just applying a per diem interest rate, the initial funded amount, and the payments, and come up with what the balance owed is. So that would be a liquidated debt. And both of these determinations are made as of the bankruptcy filing date. The case listed on the slide here, Henry Parking Management, had a pretty good discussion of both of these analyses. You determined that the lease rejection damages were contingent because it's dependent on court approval of a motion to reject, and also that determined that PPP loans were unliquidated because there was basically a chance they'd be forgiven. So next, the 50% debt test for businesses. So at least 50% of the debt needs to arise from commercial or business activities. I think for businesses, this will generally be pretty self-evident. It won't be really an issue, but I think this would come more into play with individuals. If they have, guaranteed debt that's more than 50%, then they would qualify. Last eligibility requirement I'll talk about is the single asset real estate debtor. So definition is here on the slide. Generally, it's a business that owns one piece of real estate. I think certain size residential real estate might not qualify, but so if you have a debtor that just owns a piece of real estate, it probably doesn't qualify for one piece of real estate, probably doesn't qualify for Subchapter 5. And if you lend against real estate, you might want to consider this when the company is forming, the borrower is forming entities to take the loan. You might want to consider making sure that the real estate's owned in a standalone entity if you do want to limit access to Subchapter 5. So I think that's the gamut of the eligibility issues, and I'll turn it over to Amy to talk about the role of the Subchapter V Trustee.
Thanks very much, Matt. The $1 million question, if you're representing a creditor in a Subchapter 5 case, is, why do I care about the trustee? Isn't the Subchapter 5 trustee in the debtor's pocket? And I think that is, the present thinking of a lot of creditor constituency and perhaps a lot of creditor lawyers. And I think if that is your frame of mind, you're missing an opportunity to utilize the trustee to your client's benefit. So let's talk for a minute about who the trustee is and what the trustee's duties are. From my perspective, as a practical matter, the trustee is a third-party independent fiduciary for the estate. And absent expansion of powers, the debtor remains in possession, and the trustee's duties are largely what I qualify as supervisory in nature. There are certain statutory duties that are enumerated in Section 1183B. Just to run through them quickly, the trustee has to be accountable for all property that is received during the case. Normally, that's not something that's typically done. For example, adequate protection payments aren't typically run through the trustee, although they could be. If a purpose is to be served, the trustee is required to examine and object to proofs of claim. Generally, the debtor does that. If advisable in an individual case, oppose the discharge of the debtor. Unless the court orders otherwise, the trustee is required to furnish information to parties in interest regarding the estate and the administration of the estate. So as a creditor's lawyer, that's one area. We'll talk in a minute about how can you utilize the trustee to your benefit. Use the trustee for information and document gathering. Trustee is required to make a final report and a final account and provide it to the U.S. trustee. Also is required to appear and be heard at the initial status conference, which typically happens within about 60 days of the petition date. The trustee is also required statutorily to attend hearings that concern the value of any property subject to a lien. So valuation motions under 506A, also confirmation hearings, modification of a plan after confirmation, or the sale of property of the estate. In individual cases where there are domestic support obligations, the trustee is required to provide certain notice to the holder of that claim. But unlike any other chapter of the bankruptcy code, in every case, the trustee has a primary obligation to facilitate the development of a consensual plan and to ensure that the debtor commences making timely payments under the plan. The United States trustee has published a handbook that requires the performance of additional duties. I would say, just in a nutshell, in practice as a trustee in cases, my goal is to make contact with the debtor within 24 hours of appointment. I also endeavor to attend the initial debtor interview, the 341 meeting, and every hearing in the case that I don't have a conflict with respect to, even though that's not necessarily statutorily required. The Subchapter 5 trustee's powers can be expanded by the court, either with removal of the debtor in possession or without removal of the debtor in possession, and we'll talk about that in a little bit. We've got a little lag on our slides here. Okay, so the trustee's primary role, as I indicated, is to facilitate confirmation. This is unique to Subchapter 5. That is not a duty of a Chapter 7, Chapter 12, Chapter 13 trustee. So as a result, Subchapter 5 trustees tend to be less adversarial in their role. It's designed that way. They are not marshaling assets and liquidating assets like in other chapters. And therefore, the trustee acts more like a mediator than an adversary. In fact, bankruptcy courts have analogized the Subchapter 5 trustee to mediators. Early in SBRA cases, I actually had bankruptcy judges appointing me in my role as Sub 5 trustee as a mediator. As the Subchapter 5 SBRA cases sort of evolved, I think there was an understanding and I wrote a paper on whether or not the Subchapter 5 trustee can truly serve as a neutral mediator. And sort of, I think the collective thinking at this juncture, although I'm not aware of any reported cases on the issue, collective thinking is essentially that the Sub 5 trustee can't serve as a true independent mediator. As you all may know, a mediator is not involved as a party in the underlying case. The trustee, however, is a party in interest and an estate fiduciary. The traditional mediator is subject to strict limitations on disclosures pursuant to professional and ethical standards, preventing the mediator from disclosing outside the context of mediation any oral or written communications. A Sub 5 trustee has no such limitations and may be called upon by the court after mediation concludes, particularly if it's unsuccessful, to express a position on sales of assets or confirmation or eligibility issues or other matters, and might be required to make disclosure that they become aware of during the context of sort of quote unquote mediation. And the mediator, of course, a traditional mediator can't mediate a matter that presents a clear or undisclosed conflict. In a Sub 5 trustee scenario, there's always this potential for conflict between the trustee's mediator role and its party and interest status. So that sort of begs the question of how can the parties use the mediator to their benefit, particularly from the secured creditor perspective? What kind of things can you enlist the trustee to assist with? So that would be access to documents and information regarding the case, the estate, assets, liabilities. Oftentimes you can utilize the Sub 5 trustee to obtain those things without, going to the next step of serving a 2004 examination. The other thing you can use the Sub 5 trustee for is resolving a myriad of contested matters, including objections to eligibility, stay relief motions, adequate protection negotiations, objections to claims, plan treatment issues, objections to confirmation. You can also use the Sub 5 trustee to negotiate adversary issues, including complaints for injunctions, avoidance actions under Chapter 5, and dischargeability issues. And I don't see creditors typically enlist the assistance of the Sub 5 trustee, and creditors have been, from my perspective, largely inactive in the majority of Sub 5 cases. So the next question is the expansion of powers, and that dovetails into how do you use the Sub 5 trustee to your benefit. Pre-confirmation, you can expand the Sub 5 trustee's powers in order to minimize litigation, whether it's contested matters or adversary proceedings. In the Sun Stakes case, I am the trustee, and the U.S. trustee was concerned about a massive diminution in cash that was obtained pre-petition through PPP loans, and there was probably $700,000 in cash on the petition date. In lieu of conversion of the case to a Chapter 7, my powers were expanded to require immediate turnover of the cash and an investigation and a report regarding the diminution in cash from the petition date. And then I worked with the debtor to confirm a plan that essentially vested me with the ability to pursue objections to claims and avoidance actions and make distributions to creditors. Creditors in that case were very supportive of that because conversion would have added an additional layer of administrative expense, and you've got the Sub 5 trustee with all of the institutional knowledge regarding the case to streamline that process. In the HDIP case, I represented the debtor and made an ori tennis motion to expand the Sub 5 trustee's powers to analyze a whole myriad of issues that I expected would be litigated, but for the trustee doing an investigation, analysis, and a report. And that report led to essentially proposal and confirmation of a consensual plan. I often see debtors' lawyers using the Sub 5 trustee to their benefit to minimize litigation and accomplish their objectives. I don't see a whole lot of creditors, including secured creditors, utilizing the trustee for those purposes, and I'd certainly encourage folks to reach out. Post-confirmation expansion of the Sub 5 trustee's powers is a little more dicey. So the Sun Stakes case, the powers were expanded both pre and post confirmation. That predates a new position from the Office of the United States Trustee, or newer position for maybe the last year or so. There's a concern about a conflict, or an appearance of a potential conflict between the role to facilitate a consensual confirmation and the expansion of the role to allow the trustee to step into a more lucrative liquidating trustee type role, where the trustee might be pursuing, principles for avoidance actions, and perhaps then the principals of the debtor don't have the same incentive to work with the trustee toward facilitating a consensual confirmation. So that may be limited post-confirmation. From a creditor perspective, these are also areas that you can enlist the Sub 5 trustees' assistance to the extent that you have the recalcitrant debtor. You still have the same remedies to seek dismissal, conversion, expansion of the powers, removal of the debtor in possession, perhaps revoking the small business election. Removal of the debtor in possession is a dicey issue because the Sub 5 trustee cannot file a plan even if the debtor is removed. But the threat of that removal may be enough to cause the recalcitrant debtor to consent to the enlargement of the powers and cooperate in filing a plan, because most debtors don't want to be in a position where the case is converted. Revocation of the election, there's at least one decision from the bankruptcy court in DC that ordered the revocation of the election and appointment of a Chapter 11 trustee. I think there's some debate, at least amongst the bankruptcy judges, about whether that's really a proper remedy, but there is some support out there for it. I'm going to turn it over to Rob. He's going to talk about how you challenge feasibility and analyze feasibility with respect to the plan.
Yeah, thank you very much, Amy. I appreciate it. So in my view, really, this is where the rubber meets the road on Subchapter 5. There are a lot of differences with the regular Chapter 11. We've talked about the elimination of the creditors committee, which really streamlines the process and makes it more economical to be engaged in. There's a couple other things Matt mentioned at the very beginning of this, though, that are really groundbreaking and really make this a different type of animal from a regular Chapter 11. And just going in reverse order with respect to the plan requirements on this sheet here, I think the changes to what you need to do to confirm a plan are perhaps the biggest differences. So one thing to keep in mind is you don't actually have to have any class of creditors voting in favor of a plan to confirm it, which is very different than a traditional Chapter 11. Part of the process, you think about it particularly with a public company and the like, you have a disclosure statement that you have to get approved by the court, which is in essence a stock perspective. I think analogize it to that at least. That goes out to the creditors, and they take a look through it, and then they decide if they want to vote in favor or not. And generally, you always needed at least one class of creditors voting in favor. And in smaller cases, that could be a real challenge because sometimes it was very hard to find a group of creditors that, one, had enough interest in the case to vote, and two, were going to vote as a class in favor, which was had both numerosity and dollar amount requirements. So that's all done away with respect to Sub 5. You don't actually need a class to vote in favor. You still have to get the plan approved for notice and distribution to the creditors, and they still have the opportunity to vote. But it's kind of like what was that Drew Carey show? The votes don't matter. So I don't know if anyone remembers the 90s, but he used to have a show like that. So in any event, that's one thing that's different. The absolute priority rule is abolished. So what is the absolute priority rule? This is a longstanding concept of bankruptcy that really went back to the 1898 Bankruptcy Act. so in existence for well over 100 years. And the general idea behind it, and it was originally judicially created, was that there isn't going to be any distribution to a lower class of creditor or equity holders until the class above it was paid in full. And what this meant in essence with respect to your traditional Chapter 11 bankruptcy plan, business reorganization, is that there was not going to be any distribution to equity holders of the old company unless and until one, you either got agreement from the unsecured creditors to accept less than 100% payment, or they were provided plan treatment that paid them in full. For smaller business cases, it simply was not possible to do that. And if you're dealing with mom and pop companies, for example, really the whole point of doing a bankruptcy reorganization was try to keep hold of the business. And in these type of businesses, the real value oftentimes is in the head of the founders of the business. If it's a service business, it's the relationships. It's the customer lists and that sort of thing. And the real way you monetize that value is to allow them to stay in business. So that was part of the impetus, really, one of many, I suppose, but really part of the emphasis for getting the Subchapter 5s in place. Very much akin to Chapter 13, which is an individual wage earner bankruptcy, where you don't do a liquidation like you do in Chapter 7. Instead, the individual comes up with a payment plan and pays over time. Well, that concept is put into Subchapter 5 now as well. So I'll jump up to the top now about, I kind of talked about, what's done away with. I'm going to jump up to the top here and talk about the 3 items that you have to have in a plan. So one, and this carries over from traditional Chapter 11, you can't discriminate unfairly with respect to a certain class of creditors. What does that mean? Well, you can't say, I'm going to pay unsecured creditors 50 cents on the dollar, except for Rob's client, because Rob was a real jerk through the whole case. So we're going to pay his client 30 cents on the dollar. So you have to treat creditors similarly situated equally. It's usually not that hard to meet that obligation. You can have some interesting litigation over this on occasion, but generally does not come up that much. If you're dealing with an honest debtor and competent counsel, they're really just trying to get to a deal. So the discrimination thing, it comes up on occasion, but more likely than not, you're not going to come across that in your typical case. The 2 things that you really look into, and it becomes very much a mathematical exercise, are the next 2 items, which is what's called the best interest test. And every plan that's put together, every solicitation has, for the confirmation of that plan, needs to have a liquidation analysis included with it. Typically, a debtor is going to have their financial advisor come up with this. If you don't have a financial advisor, first of all, you should probably have one, because you've got to do monthly operating reports, which can be somewhat challenging to do without one, particularly in more complex small businesses. But with respect to this and the liquidation analysis, that's going to be included in the plan. It's going to show if we shut down this business today and liquidated everything, this is what we project would go to each of the different classes of creditors. This is what each one of the secured creditors would get. Maybe there's a blanket lien that covers equipment, receivables, and the like. Maybe there's a mortgage on a building. Those are going to get whatever treatment they're going to get. A lot of times you're going to see those ride through the plan. They don't necessarily have to. We can talk about, distinctions with respect to that, particularly when I get into the 1111B election coming up. But you've got to show how the plan that you're putting together is going to be better than if you just shut the doors today and liquidated everything. And that's really what's meant by the best interest test. And then the last item we're going to talk about a little bit in our coming slides has to do with the requirement to pay all projected disposable income for 3 to 5 years. So I just mentioned the last item, projected disposable income PDI for 3 to 5 years. And that gives rise to a number of interesting topics and issues. So what exactly is projected disposable income? And how does it relate to actual disposable income? It can be tempting for a debtor, for example, to say, well, whatever I actually have in disposable income for the next however long my plan is, 3 years, 4 years, 5 years, I'm going to pay that, and that's what it's going to be. I'll flip forward to the next slide here. There's at least one case, which is the Orange County bail bonds case from the Ninth Circuit, BAP, which would be out California way and the like, that a plan that pays actual disposable income does not meet the requirements for confirmation because it does not commit the debtor to pay what it projected. And what the statute actually says is pay projected disposable income. So to the extent your plan is, I'm just going to pay what actually comes in, that's probably not going to work. There can be interesting discussions between creditors and debtors on paying the greater than amount. If you're the debtor, I think you probably want to resist that. When I say the greater than amount, that would be, the actual versus whatever you project. And again, when we're talking about projected, these are calculations that the debtor is going to come up with their financial advisor in the bankruptcy as to what they think their income that they can devote to pay creditors over the next several years is going to be. I'm just trying to flip the slide here. So when arriving at projected disposable income, what does it take to get that number? Obviously it's not all revenues for the business. So this chart kind of shows you some of the deducts that you can take from that. Obviously, there's a section here talking about individuals because, as Matt mentioned at the beginning, if you meet certain requirements, an individual can file a sub-5 case. In those type of things, you'd be looking at deduct for actual living expenses, lifestyle issues come into it. Are you entitled to take a vacation or not, or do you need to pay your creditors? There's means testing that goes into when you file a Chapter 7 versus 13, which I think it's a little bit beyond what we're here today to talk about. But this could come up in the context of if you're a secured lender with a guarantor who ends up filing bankruptcy and you're trying to collect on the guarantee. From the company side, really you're looking at total revenues, and then you're going to take out the obvious deducts that you would take out for the business. So obviously wages for employees and cost of goods sold and that sort of thing. There's some other issues that come up that can be the subject points for discussion. What type of reserves does the business need? Is there an expansion that's needed? What type of money should be held back from what would otherwise go to creditors to cover that? What about the owners and insiders compensation? How much should the owner of the business who's preserving the equity get paid as compensation going through in the case? And also pass through tax obligations for the owner. Obviously, if it's takes sub-5 tax treatment, the income that's generated, which is fairly common for a small business debtor case, Subchapter 5 case, you would expect that. The business isn't going to actually be paying its tax obligations. They're going to pass through. So should that be covered as well? Sorry about this, folks. One other issue that can come up is how long the plan is going to be. You can see on this slide here in the upper left side, the bankruptcy section, which requires, and again, we're talking about a non-consensual plan here. So if you have something that everyone agrees to in a plan, you get a lot more flexibility. But in general, what the statute requires is all the projected disposable income of the debtor to be received in the 3-year period or such longer period not to exceed 5 years. So the absolute max you can have for a plan is 5 years. And it varies. You need to know who your judge is and know where you're at as to what your judge's idea is as to how long a plan should go. Looking at the statute, it says 3 years or such longer period. How I've always viewed that is, if you can meet the best interest test in 3 years, in other words, if you in 3-year period you're kicking out enough income from your business that you can pay more than the liquidation value, then that should be enough. Some judges don't look at it like that, and Amy can certainly speak to experience in Tampa and Fort Myers, but I think until fairly recently there was an expectation that traditionally Chapter 11 plans last 5 years, so that's how long Subchapter 5 plans are going to last.
Yeah, so just a quick update sort of on the custom. I mean, I think the know your district, know your judge rule is really important. In the Northern District of Florida and Jacksonville and Orlando, which are divisions of the Middle District, the custom has essentially, or the default plan term has been 3 years. I think since the inception of SBRA. Some of the Tampa Fort Myers judges have been following more of the 5-year rule, perhaps following, the lead of the U.S. trustee and the sub 5 trustees that traditional 11s are 5 years. So why shouldn't a sub 5 case be 5 years? I think some of the judges in Tampa are being influenced by the fact that folks are pointing out that the statute is different. Yes, this is a Chapter 11, but SBRA has specific statutory provisions that are different from traditional 11s. They're not identical, and the statute says to be received in the 3-year period. So that is the default unless the court exercises its discretion and extends that period to 5 years. And I think that a lot of judges' view of the world is because a sub 5 is a small business case and it's designed to get small businesses in and out quickly and cheaply. The way to do that is to confirm 3-year plans. So I think that custom may be changing.
Yeah, Amy and Matt, we had a couple of questions that came in as well. So the first one was, how frequently are you seeing consensual versus non-consensual plans confirmed? Amy, you see these every day, so I'd be particularly interested in your view on it. But at least what I've been seeing through my more limited sample size is that it varies very much case to case and how aggressive a debtor is going to be. But I think there's a real push, particularly by the Subchapter 5 trustees like yourself and the courts to get to a consensual plan if at all possible.
So let me answer the first question, which is, I think the bulk of plans that are confirmed non-consensually. And the reason for that is there's not a lot of creditor participation, and a lot of creditors simply choose not to vote. In some jurisdictions, no vote equals deemed acceptance. That is not the case in the Middle District of Florida, and I think the rest of Florida. So no vote is not no problem. It is a problem. It means you do not have the vote requisite to confirm the plan consensually. The SBA, as a matter of policy, will not vote. And so if they're a creditor, you're not going to have a consensual plan, even if everybody else consents. There are some consensual confirmations, but you also see other secured creditors who don't vote like the SBA, and that causes that same issue. From my perspective, the courts are kind of the ones pushing for consensual confirmations, and oftentimes we'll try and see whether the parties want to kick confirmation down the road a little bit to see if they can get some more votes. As a trustee, I don't necessarily push for that because I think that there are occasions and cases where no matter what you do and how long you delay it, you're not going to get the votes, and you don't need it statutorily. So why not just confirm it and accomplish Congress's goal of getting these cases in and out and confirmed quickly? The other thing is, and I won't spend a whole lot of time on this, but there's some sort of academic debate about, do you really want a consensual plan? If I'm the debtor, I don't want a consensual plan. I want a non-consensual plan, at least in a corporate case, because then the debtor has the ability to modify if circumstances change significantly. If it's confirmed consensually, can't modify, and I'm stuck if there's a significant change in circumstances and the debtor can't perform.
Yeah, that's interesting. I guess maybe that goes back on the point I was saying earlier about how the votes don't matter, and you're raising a really good point, Amy, because ultimately you can emerge from bankruptcy with no creditor support, but the consequences of having a consensual or a non-consensual plan are very important as you go through the confirmation process. Other question we had, I'll just answer very quickly. How much disagreement are you seeing regarding the calculation of liquidation value or disposable income? Again, I would say this varies case to case and how aggressive the debtor wants to be and the creditors. I suppose to Amy's point, if you've got a creditor body who's very disengaged, they're not necessarily going to litigate over this. In certain cases, though, where you've got a high value item, or you've got a company that's generating a lot of income, it could be very important and it could be very heavily contested. And in fact, you could have expert witnesses testifying about it if there's enough money to fight about.
Yep. I would say I don't really see much change compared to before sub 5. I think it's kind of the same factors, same situations where you'd see the litigation.
I'm not seeing a whole lot of litigation over those issues. I mean, certainly there are more significant, more sizable cases, but I think the litigation is, on the sort of minority end.
I'm going to try and get us back on track. We slowed down a little bit, unfortunately. I apologize for that. I'm going to talk about the 1111B election next. This has to do with rights of a secured creditor with respect to a security interest in a specific asset or specific piece of property that's owned by the debtor. And it's very, very rarely used. It could be more impactful in a Subchapter 5 case than in other situations. And so I'll try to talk about that quickly. The important point to keep in mind, if you're a secured creditor, in bankruptcy, your claim is really divided into two portions, a secured portion and an unsecured portion. Typically, you're only a secured creditor up to the actual value of your collateral. So if your collateral is a parcel of real estate, and we'll just say it's worth $100,000, then that is the secured portion, even if there's a mortgage on it that's for $1 million or something like that. What the 1111B election allows you to do is to have your entire claim treated as secured, meaning that as part of any plan of reorganization, the debtor is going to have to pay the full value of what's owed. Now, you might say, well, why wouldn't a secured debtor do that in every case? And there's a couple of reasons why. I suppose one is, and this isn't important in sub 5, as it is in a general Chapter 11, but if you treat your entire claim as a secured claim, you're going to lose your blocking position to vote your unsecured claim. And the other thing is that you're going to lose your right to participate as an unsecured creditor for the undersecured portion of your claim. If you do make the election, then the other thing to keep in mind is you don't get paid the amount of your claim with till interest. Matt was talking about till interest before, and I don't want to go into too much detail on this chart here, but in essence, if you can look at the 5-year portion here, you're going to get interest. This is looking at a claim with a value of $30,000 and a total amount owed as $100,000. So you're going to get interest on your first $30,000 under the bankruptcy code, and then the rest is just paid dollar for dollar without any time value of money calculation. And one thing to keep in mind is with certain types of collateral, such as real property, it's possible you might get a very long plan and it might be confirmed. So look at the 53-year plan calculation at the bottom, where you get a very small dollar amount for a very long period of time, and that might be what you get. The other thing to keep in mind if you make the 1111B election is you might be making it much harder for the debtor to confirm a plan. And And if you do that, you might be forcing a liquidation. And there are some strategic decisions where that makes sense. There's other times where it doesn't. One other thing to keep in mind, I'll just touch on this very briefly, is to the extent that the property is of inconsequential value, your security interest, the collateral you have, you might lose the right to make the 1111B election. And I'll turn it back over to you, Matt, then to talk about negotiating default provisions, et cetera, et cetera.
Sure. Yeah, thanks. And I know we do have a couple more questions. I think we'll try to get through our last bit of material and then turn to the questions at the end here. So negotiating default remedies. So there, Rob talked about some of the requirements in a traditional Chapter 11 case that still apply in a Sub 5. One of those is the feasibility requirement. It is slightly tweaked in Subchapter 5 cases for the non-consensual cases at least, and the statute's summarized here. But to confirm non-consensual Sub 5, the court needs to conclude either A, that the debtor will be able to make its planned payments, or B, that there's a reasonable likelihood that the debtor will make its planned payments, plus some sort of additional default remedies are provided. The first route, concluding the debtor will make the payments, not a lot of case law discussing that. It seems like it's a pretty high bar where you'd likely have to place funds in escrow, have a guarantee from a very solvent party showing that almost certainly the payments would be made. Under the second route, the debtor just needs to show a reasonable likelihood that the debtor will make its payments. The additional default language is quoted here, requires that a plan provides appropriate remedies to protect the holders of claims or interests in the event that payments are not made. And again, there's not a lot of case law yet interpreting this, but the cases I did find say that it just requires more than letting debtors go pursue their state law remedies, which include in some of my plans. I guess I need to step that up a little bit. And so the next slide here lists some potential remedies you could ask for as a secured creditor. What I see most often requested is some sort of shortcut default, declaring a default and termination of automatic stay. So instead of having to file a motion with the court to terminate the stay, telling the court there's a default, then having to set a hearing, you might request just the ability to file an affidavit signed by loan officers saying they defaulted. Maybe there's some shorter cure period, 10-day cure period, they failed to cure, and that process would be laid out in these default provisions, and to provide that the automatic stay would terminate. Because in a non-consensual case, the automatic stay does remain in place throughout the payment period, and that's a little different than I think a traditional Chapter 11 as well. So here are some other, I think what are more aggressive, default remedy requests, like a deed in the drawer, stipulation to judgment. I don't know if these would be required to satisfy the statutory language, but if you're requesting these as maybe you're giving on something else, agreeing to the favorable plan, treatment, or interest rate, maybe you can ask for a more aggressive default remedy to make the case work. I think the liquidation of assets by the Subchapter 5 trustee or debtor, that seemed, I think that was mentioned in one case where the plan could provide that in the event of a default, the debtor agrees to auction off a piece of property, for example. So that would seem to be appropriate as well. So Amy, I think you're going to bring us home here.
I am, thanks. Just a quick point on some of these issues. Normally you see, a general default remedies provision in the plan, and Matt's right. I think most debtor plans basically say, creditors, secured and unsecured, can go pursue, their collateral or their rights to the extent they have no collateral in a court of competent jurisdiction. The U.S. trustee and the judges don't particularly like that language, but oftentimes it does slide by if creditors aren't negotiating additional default provisions. If you're a secured creditor, as opposed to an unsecured creditor, though, one sort of interesting twist would be negotiate plan treatment related specific default provisions that apply only to your creditor's class claim. So if you're in class 2 and you're Wells Fargo, you're negotiating specific default provisions related to your collateral and your claim, not general default provisions that are going to benefit the rest of the creditor constituency. That's something else to think about. Okay, so this is kind of a bizarre case, but I guess a trap for the unwary. Recent case where I was appointed as a successor trustee to the previous trustee. Plan was confirmed. The plan had a modified payment to Truist Bank in connection with the vehicle loan. It was, different rate, different amortization, lower payment. The plan was confirmed, case was dismissed after confirmation, and the dismissal order bound all parties to the terms of the confirmed plan. So Truist was supposed to update its books and records to reflect the reduced monthly payment. They did not do that or do it well internally. There was no discharge injunction, of course, because the case was dismissed. There's no automatic stay in effect. The debtors made all of the modified per the plan payments to Truist. Truist declared a default based on the fact that their system showed this higher payment, and then defaulted the debtors and repossessed the vehicle. The debtor sought to reopen the case and require the return of the vehicle and impose sanctions on the bank for violating the order confirming the plan. The court ordered the return of the vehicle and essentially reinstatement, if you will, of the loan in accordance with the confirmation order. The sanctions issue is still pending and not resolved. I suspect the parties are going to cut some deal that involves Truist paying attorney's fees and costs, and perhaps some value associated with the lost use of the vehicle during the repo time. But this is sort of a trap for secured creditors. Just be mindful of situations where a plan is confirmed and then later dismissed. Make sure that the accounting is updated. Got a little lag on our slides here. All right, so practice pointers, and I lost it.
I think yeah, go ahead, Amy. Go ahead.
Quick practice pointers. So if you're going to challenge eligibility, you have 30 days after the conclusion of the 341 to do that. So from the petition date, you have 60 days to analyze that eligibility issue. You can't wait until the case is 10 months old to consider that objection. I had that in a case where a lawyer reached out and said, hey, I think I'm going to object. And I said, I think the clock ran out, the sand's out of the hourglass. So get sort of your ducks in a row if you think that eligibility is truly an issue, and use the 341 meeting and Rule 2004 to conduct your examination to determine whether there's a basis for an eligibility objection. Use the Sub 5 trustee. I can't stress that enough to creditors. Use the trustee to help facilitate resolution of issues, either issues that you're going to tee up, issues that the debtor has teed up. It'll save your client time and money. And if you have something that can be de facto mediated by the Sub 5 trustee, unless you have a true concern about mediation privilege, use this trustee, because the trustee's fees are being paid by the estate. It's not a mediator 50-50 split where each side pays half. So from a secured creditor's perspective, that's a win-win for your client. And in my experience, the Sub 5 trustees are all, competent and highly effective. Section 1111B, highly underutilized by secured creditors, can be an effective tool because you don't need that blocking vote. The only cautionary tale is be careful. If your collateral, if you're owed $4 million and the debtor was going to value your collateral under 506A at $2 million, and you make the election, if you making the election makes the plan not feasible, and the debtor ends up dismissing the case or converting, and you get your collateral back and it's really only worth $1 million, I don't know if that's a win. And then make sure you pay attention to the plan default remedies. And as I said, if I were representing a secured creditor, I'd be negotiating remedies for my client only in that class treatment as opposed to in general. We didn't talk a lot about 523A. There's some exceptions discharge that apply. more in individual cases, not a whole lot of those, but a few individual cases in the sub 5 context. So if you get one of those, don't ignore that as a potential remedy. And then interestingly enough, the code provides for the discharge to take effect in a consensual case, essentially upon confirmation. And I had this case, Beeline Carriers, where we confirmed, I represented the debtor, we confirmed the case, and discharge, injunction, if you will, would have gone into effect. My recollection is it was a consensual case, but I don't recall. But essentially, you don't want to have a scenario where you've got the discharge effective before the effective date, and then there's a default. So that's a rare case, but that happened in the Beeline case. We didn't even make it to the effective date or substantial consummation because the debtor couldn't obtain renewal insurance for its fuel transport carrier business because of the cost of renewal insurance. And so, here we had a scenario where the plan, was confirmed and there was a discharge injunction in effect, but it hadn't even become effective. So, Rob, did you or Matt? Let's see what questions.
Yeah, one of the questions I know, and I think we're out of time, but I don't mind staying on a couple of minutes to answer questions. Amy, there's a question asked about the flexibility on a non-consensual confirmed plan versus consensual. And I think it just comes down to the statutory language that in a consensual confirmation, there's no ability to modify. And I know one of our judges here held that in a case. I'm not sure if it was published or not. That based on the language, you can't modify a plan in a consensual case. So if you go to confirm, maybe think about non-consensual might be better if you want to retain the ability to reduce the plan payments potentially if the debtor's performance isn't as you projected. You could potentially go back to court, modify the plan to reduce the projected disposable income.
So Matt, that's right. 1193B, you can modify a consensual plan, but you have to do it before substantial consummation, which generally means you've started making the plan payments. So in a consensual case, if you've started making the plan payments and substantially consummating it, you've cut off your ability to modify. So from my perspective, if it's a corporate case, I'd rather have a non-consensual case where I can go back and modify for a change in circumstances. And I don't really care about the fact that the debtor's discharge is delayed in a non-consensual case until the plan payments have been made. Some judges and academics have suggested that in an individual case, you might prefer to have, a consensual confirmation because you get the discharge immediately in a consensual case, and maybe that outweighs the potential need to modify later.
Yeah, and I had one client who just wanted to get out of bankruptcy. So, getting the discharge rather than having the case stay open and be in bankruptcy, dealing with, trustee for 3 years. I think one of the customers thought it was important to have them out of bankruptcy. So that could be a concern. Should hopefully be able to talk them out of that or talk around that.
Yeah, we had another question on the 1111B election as well, and its relationship to Subchapter 5. I think the point with respect to the blocking position is that since you don't need a class voting in favor, you don't necessarily, the blocking position is really worthless in a certain respect with respect to the sub 5, because you're not going to be able to control the unsecured creditors with your undersecured claim, which might motivate you to make the election, subject to the caveats you talked about, Amy, is be careful what you wish for, because you might be looking at a case dismissal or something like that.
Yeah, on the economics, and I don't know if the question was sort of geared toward the economics, but if your client is owed $4 million in a traditional case, where you have a bifurcated claim and the debtor says the value of the collateral is $2 million, well, you're probably hesitant to make the 1111B election and try and collect the full value of your $4 million claim, because you want that bifurcated unsecured claim of $2 million, which hopefully is the blocking position for the unsecured class. But since you don't need one creditor to vote in favor in order to confirm a sub 5 plan, that blocking position is completely worthless. And the idea is, secured creditor, wouldn't you rather have $4 million than $2 million? Well, plus whatever de minimis distribution you're getting in the unsecured class. Well, the answer to that is usually, well, yeah, of course, we'd rather have the 4 million, unless of course the debtor is stretching the 4 million out over 50 years and the court confirms that, or alternatively, the debtor says, well, the 4 million is not feasible, and so be careful what you wish for. Here you go, your collateral, you can have it back, and it's really only worth $1 million.
Yeah, I suppose a couple of things with the 1111B election that are helpful is if you've got that in the back pocket, that can help you negotiate over an agreed value. And it also protects a secured creditor in a situation where maybe there's something strange going on with the economy at the moment, where the value of your collateral has plummeted through the floor, but everyone believes that it's going to go back up to what it was in a year or two, that sort of thing. So it'll protect you from a situation where your collateral has artificially gone down in value right at the time that the case is being confirmed. And I think that is probably it at this point. We thank everyone for being on. It's a lot of fun with you, Matt and Amy. And I guess stay tuned for a couple more months and we'll do another one of these webinar sessions here at TMA. So thank you very much, everyone.